Hello to my subscribers and to all of you who are watching this video. Welcome to another episode of Legal Tips at Your Fingertips. This is Attorney Chato Olivas. Our topic for today is entitled, You Can Settle Your Deceased Parent's Estate Without Going to Court. Has your parent passed away and left a house and lot, vehicle, bank account, shares of stock or other property in his or her name, and you as well as your siblings don't know what to do? These properties form part of your deceased parent's estate, which you cannot transact on unless the estate is settled. By settled, I mean the distribution of the properties to the heirs. As a child of the deceased, your co-heirs would be your surviving parent and your brothers and sisters. If you are governed by Philippine law, you can settle your deceased parent's estate without going to court if these three requirements under Philippine law are present. Number 1, there is no last will and testament. Number 2, there are no debts. Number 3, you and your co-heirs are all of legal age, or if there are minors, they are represented by their legal representatives. If these requirements are not present, you will have to file a court proceeding for the settlement of the estate. For those who are citizens of another country or state, you must consult legal counsel on the requirements of your national or state law. Under Philippine law, you and your co-heirs can execute a document known as extrajudicial settlement or EJS, in which you specify how you would like to divide the estate among yourselves. It is always advisable to consult a Philippine lawyer about this just to make sure that the substance of the EJS complies with the law. The EJS should be notarized and a copy submitted to the Register of Deeds where the land or real property is located. You must also post a bond with the Register of Deeds equivalent to the value of the personal property such as shares of stock, vehicle, bank account, and others. The phrase personal property has a legal meaning in Philippine law. This refers to properties that are not land, house, condominium unit, or real estate. This bond is effective for 2 years and will answer for claims filed by excluded heirs or creditors. You also need to publish a notice that the estate has been settled extrajudicially. This is a tiny notice in the classified ad section of a newspaper of general circulation, and it should appear once a week for 3 consecutive weeks. After 3 weeks, go to the newspaper company and get the publisher's affidavit of publication, plus the actual 3 issues of the newspaper where the notices were published. Newspapers are familiar with this requirement, so you don't have to give a lot of explanation. They will have this ready for you after 3 weeks. And then you can now fill in the estate tax return and submit this to the Office of the Bureau of Internal Revenue in the city or municipality where your deceased parent last resided. It is better to seek the advice of an accountant in filling in the estate tax return. The estate tax is 6% based on the net value of the estate. Once the estate tax return is filed and the tax due is paid, if any, the BIR will issue a Certificate of Authority to Register, also known as CAR or CAR. You can now transfer the title to your name and that of your co-heirs as co-owners by submitting the following documents to the Register of Deeds. Number 1, extrajudicial settlement. Number 2, affidavit of publication. Number 3, estate tax return as filed with the BIR. Number 4, official receipt to prove payment of estate tax, if any. And number 5, certificate of authority to register. To watch more videos of this nature, I ask you to subscribe to my channel. If you are a law student, you may want to read about remedial law in my virtual textbook on this subject at www.profchato.com. And I would like to share my favorite Bible verse with you, which is found in Micah chapter 6, verse 8. Do justice, love kindness, and walk humbly with God. This is Attorney Chato Olivas, making the law easier to understand. See you next time.